Welcome to the Supreme Court Podcast.
All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
A tripartite agreement between state-owned corporations of three countries for the conduct of a seismic survey in an area in the South China Sea is voided by the Supreme Court for violating the Constitution. What can be considered exploration of natural resources? Who can be authorized to do it? And what are the limitations? Hi, I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. It's the 8th of November 2024, and today we talk about the case of Bayan Muna Party-List Representatives Saturo Campo and Teodoro Casino versus President Gloria Macapagal Arroyo, decided on January 10, 2023. It's an unbanked decision penned by Supreme Court Associate Justice Samuel H. Guerlan. And joining us to talk about this case is Attorney Catherine De La Rosa Versosa from the Office of Associate Justice Guerlan. Hi, Attorney Cates. Thanks for joining us. Welcome to the Supreme Court Podcast.
Hi, Attorney Mike.
So, Attorney Cates, let's talk about this Bayan Muna case, which involves a tripartite agreement for Joint Marine Seismic Undertaking, or JMSU. What is this JMSU and who are the parties involved?
So the agreement involves the national oil companies of the Philippines, of China, and Vietnam. For the Philippines, it is PNOC, or the Philippine National Oil Company. For China, it's the CNOOC, or the China National Offshore Oil Company. And for Vietnam, it is Petro Vietnam, or the Vietnam Oil and Gas Corporation. So basically, the agreement states in its fourth whereas clause that the parties would like to express their desire to make the South China Sea in an area of peace, tranquility, development, and cooperation, because these three countries, the Philippines, China, and Vietnam, are laying claims on the part of South China Sea, which is the agreement area talked about in this agreement. So, in addition to that, the fifth whereas clause of the agreement states that the parties would like to conduct a joint research on the petroleum research potential of the agreement area as a pre-exploration activity.
All right, so for context, which area was covered by the JMSU?
So the area covered is that part of the South China Sea, which the Philippines considers as part of its territory. So the petitioners in this case allege that it is part of the Philippines Economic Zone, and which includes around 80% of the Spratly Group of Islands, and this is not disputed by the respondents.
So what were the objections to the JMSU? Why did petitioners question it before the Supreme Court?
So there are two objections. First, because the agreement involved large-scale exploration of our petroleum resources in the part of the South China Sea, which we claim to be part of our territory. So the exploration would be conducted by corporations which are foreign-owned, that is Vietnam and also China. And second, because the agreement would not fall under any of the modalities under Article 12, Section 2 of the Constitution pertaining to the modes allowable for EDU, or exploration, development, and utilization of natural resources.
Right. And who are the petitioners in this case, and what's in it for them? What do they stand to lose with this JMSU?
The petitioners in this case are actually members of the House of Representatives. Particularly, they are party-list representatives from Bayan Muna, Anak Pawis, and Orso Gabriela. They are suing as legislators, taxpayers, and concerned citizens. So first, as legislators, they argue that the execution of the contract would encroach upon or usurp the power of the Congress, because under the Constitution, once the President enters into an agreement with a foreign-owned corporation with respect to the exploration of natural resources, large scale, the President should report it to the Congress within 30 days from execution, and the Congress would have to review it. But here, the PNOC was the signatory to the agreement, so the Congress has no chance of reviewing it. So that's the first. The petitioners are also suing as taxpayers. They claim illegality of disbursement of public funds because they allege that the JMSU is illegal because it contravenes Article 12, Section 2 of the Constitution. The funds of the PNOC is public funds because it's appropriated by Congress.
Right.
And the third one, they are actually suing as concerned citizen. So they invoke transcendental importance of the case. So there are three factors that you should know in order to determine if the issue is of transcendental importance. So number one, the character of the assets or the funds involved. Number two, a clear case disregard of the Constitution. And number three, there is no other party which has more direct or specific interest. And all these requisites are present in this case because number one, the GMSU involves the petroleum resource potential of a part of the Philippine territory. So that's vital. And then number two, there is a alleged disregard of the Constitution, particularly on large-scale exploration of natural resources.
But Attorney Cates, when you look at the facts of the case, the JMSU was signed in 2005. It expired in June 2008. Why did the Supreme Court decide to resolve it? Wasn't it moot at that point?
Attorney Mike, I agree. The case is already moot and academic because the case was filed around 2008 and then the same year, the GMSU expired. But when you say the case moot and academic, it ceases to present a justiciable controversy because of introduction of supervening events so that any declaration thereon would be of no value. However, the moot and academic principle is not a magical formula that would dissuade the court from recognizing a case, especially when any of the exceptions to the moot and academic principle are present. So there are 4 exceptions in this case which are present according to the ponensya.
Right.
So number one is there is a grave violation of the Constitution, particularly Article 12, Section 2. Then second, the topic is of paramount public interest, exceptional character because it involves the petroleum resource of the Philippines in the South China Sea. Third, there is a need to formulate controlling principles for the guidance of the bench and the bar. In this case, the court is tasked to answer the novel issue of what constitutes exploration under the Constitution. And number 4, the case is capable of repetition yet evading review because the Philippine government may later on encounter contracts of the same character as the JMSU.
Right. So for the guidance of future contracts, the court needs to resolve this. Now, let's go to the substance of the case. The petitioners claim that the JMSU involves exploration and therefore prohibited under the Constitution. On the other hand, the Solicitor General representing the state said it involved pre-exploration activities and therefore it's not covered by the prohibition. So for us to resolve this, can you walk us through what exactly seismic work or seismic survey entails?
Seismic survey is actually a geophysical survey method. So in layman's term, it is used to determine the existence of petroleum or gas in a given area.
So you're mapping out the terrain to see if there's a potential source of petroleum that you could later on extract.
Yeah, you're collecting data.
Right. So does seismic work or seismic survey amount to exploration?
Yes.
But in the first place, what does the term exploration mean? What does it cover?
Well, exploration, whether in ordinary or technical sense, means the discovery or search of valuable natural resources.
Right. So, in her dissenting opinion, Associate Justice Ami Lazaro Javier said, the JMSU does not involve exploration because exploration must involve the extraction and carrying off of natural resources. How did the ponensya address this point?
The ponensya referred to the case of Apex Mining versus Southeast Mindanao Gold Mining Corporation, where the court categorically declared that exploration does not include development and utilization. That is the extraction or the moving or the using of the mineral or the petrol found in a given area. So when you say exploration, it only means that you are searching or you want to discover whether a certain area contains minerals, petroleum, or oil.
So what happens when Justice Ami Lazaro says there should be extraction and carrying off of natural resources? How would you characterize that act already?
That's no longer exploration. Rather, it is utilization of natural resources.
So even if it doesn't amount to a product that's being sold or extraction of petroleum per se, as long as you're extracting something, that's already considered utilization.
Yes.
All right. Now, under the Constitution, how can exploration along with development and utilization of natural resources be conducted?
There are actually 4 modes under Article 12, Section 2 of the Constitution. Number 1 is it may be directly undertaken by the state. Number 2, there is a co-production, joint venture, or product sharing agreement with Filipino citizens or qualified corporations. Number 3, the Congress may by law allow small-scale utilization of natural resources with Filipino citizens. And number 4, with respect to large-scale exploration, development, and utilization of natural resources, the President may enter into agreements with foreign-owned corporations involving financial or technical agreements.
Mm-hmm. All right, so Attorney Cates, before we look at whether the JMSU falls under any of the 4 modes, can we define some terms first? For example, you mentioned financial and technical assistance agreement. What does it entail?
Well, as the phrase states, it's about financial or technical assistance with respect to large-scale exploration of natural resources.
So that means you are just providing financing
Money.
or perhaps technical expertise. You're
Yes.
not the one undertaking it.
Yes.
You're not a partner.
Yes, you're
Right.
just training the country, for example.
Right. And what about the service contract?
When you say service contract, it means that service and technology is provided by a service contractor, and you have to pay the service contractor for a stipulated fee, and the country would be the one financing it, and the petroleum or any product that would be get from that, it will be owned by the country.
All right. So to be clear, the GMSU that we're describing here, does it fall under an FTAA? Does it have a service contract? Or does it fall under any of the 4 modes of exploration of natural resources?
The Ponencia declared the JMSU unconstitutional because it does not fall in any of the 4 modes. Because number 1, it was not directly undertaken by the state. It's
Right.
undertaken by the Philippine National Oil Company with the counterparts, national oil companies of China and Vietnam. Second, with respect to the second and third modes, it does not involve Filipino citizens or qualified corporation. It involves foreign-owned corporations. And number 4, it cannot also fall with number 4 because it was entered into by PNOC and not the President.
And there's no FTAA here. There's no service contract that was
Yes.
signed.
Yes. Even the respondents themselves stated that this does not involve a service contract. They admitted that.
Right. So if the JMSU was neither an FTAA nor a service contract, could there have been any other way to make it constitutional?
Actually, there is no other way to make it constitutional because Article 12, Section 2 of the Constitution is clear that for large-scale exploration of natural resources, just like in this case, exploration, it should be the President who should enter into contracts with foreign-owned corporations.
Right. There was an argument raised here by the state through the Office of the Solicitor General. They're citing a memorandum of understanding with the Australian government, which supposedly allowed an Australian survey vessel to operate in Philippine waters to gather seismic data. Wasn't that comparable to this case?
No, it actually differs on 2 grounds. Number 1, with respect to objective or purpose. Because the MOU with Australia, the government of Australia will provide us with training, assistance, so that in the future we could do exploration more efficiently.
Right.
But in this case, JMSU, it is actually the CNOOC and Petro-Vietnam who would be conducting joint research with PNOC. And then the second difference is the parties involved because the JMSU involves PNOC, CNOOC, and Petro-Vietnam. So they are the national oil companies of these 3 countries. While in the MOU, it is actually the government of the Republic of the Philippines and the Australian government themselves who would enter into an agreement.
Right. Is there merit to the argument that what was involved here were state-owned corporations separate from their governments?
No, the Ponencia stated that it doesn't matter that it was the PNOC, CNOOC, or Petro-Vietnam who appear to enter into an agreement with each other because Article 11.6 of the JMSU states that the agreement would not be binding if they would not be able to get the approval of the respective governments. Particularly, the 8 whereas clause of the agreement stated that with the authorization of the Philippine government, PNOC is given the exclusive right to enter into an agreement. So it means the government gave its approval. And in fact, the facts of the case stated that permit was given by then DOE Secretary.
So, mere approval by the government is still not enough to satisfy the
Yes.
requirements under the Constitution.
Yes.
There has to be, or it has to be at least,
The President.
the President has to enter into a contract for an FTAA or a service contract for this to be valid.
Yes.
Right. Now, what about the dissent of Associate Justice Ami Lazaro Javier? She was saying that the JMSU should be treated not just as an exploration, development, utilization agreement, but as a foreign relations instrument, and therefore, there should be some form of differential treatment. How did the main opinion address this?
Well, the JMSU is not a foreign relations agreement or instrument because in the first place, it was not entered into by the President, who is the chief architect of our foreign policy. So the respondents themselves stated that the President has no hand in the JMSU and not a part of the agreement because it is actually the CEO and the President of PNOC who signed the agreement.
Right. Now, Attorney Cates, how significant do you think this case is to future agreements involving exploration, development, and utilization of natural resources?
Very significant because now that the Supreme Court was able to determine the meaning of exploration of natural resources, the government would be more mindful in entering into contracts which purports or disguises to be pre-exploration activity when in fact it already involves exploration of natural resources.
All right. So, Attorney Kate, this has been a very enlightening discussion. Thank you so much for your time and for your thoughts on this issue. All right.
Thank you, Attorney Mike.
All right. And if you wish to read the full text of the court's decision, you can go to the Supreme Court website and e-library. Just search for Bayan Muna Party-List Representatives Saturo Campo and Teodoro Casino versus President Gloria Macapagal Arroyo, GR number 182734. And your Stiff Atendido Beltran, Supreme Court Information Officer for this week's Roundup.
At the Supreme Court this week. The Supreme Court fined a judge for undue delay after taking 7 years to resolve a prayer for a writ of preliminary injunction. The court found presiding judge Miguel S. Asuncion, Branch 99, Regional Trial Court, Antipolo City, Rizal, guilty of gross neglect of duty and fined him 201,000 pesos. The court deemed Judge Asuncion's 7-year delay in resolving the matter as inexcusable, emphasizing that a request for a writ of preliminary injunction must be treated with urgency. In another decision, the Supreme Court stressed that imprisonment beyond the maximum penalty is not only cruel and inhumane, but also undermines the dignity of detainees. The court affirmed a woman's conviction of qualified theft, but ordered her immediate release from detention due to service of sentence. The court emphasized that the power of the courts to commit prisoners carries with it the duty to immediately release them in case of detention for a period equivalent to or longer than the maximum imposable penalty. The Supreme Court welcomed the enactment of new laws establishing additional trial courts in the country. Republic Act numbers 12044 to 12054 created 37 additional regional trial courts, 2 metropolitan trial courts, and 21 municipal trial courts in different cities and municipalities in Luzon, Visayas, and Mindanao. Australian mission to the Association of Southeast Asian Nations Ambassador Tiffany MacDonald congratulated the Philippines on the development of the victim-sensitive guidelines in the justice system during a courtesy visit on the Supreme Court justices, represented by Chief Justice Alexander G. Gismundo and Associate Justice Maria Filomena Dising on November 5, 2024. The guidelines is an initiative of the Justice Sector Coordinating Council, or the JSCC, which is composed of the Supreme Court, the Department of Justice, and the Department of the Interior and Local Government. From November 6 to 8, the Supreme Court held various consultations with stakeholders to get input, suggestions, and feedback on proposed amendments to existing rules. The consultations aim to engage judges, court personnel, legal practitioners, and the academe in discussing the proposed new Code of Conduct for court personnel, the proposed new Code of Judicial Conduct for the Philippine Judiciary, and the proposed amendments to the Rules of Civil Procedure and Criminal Procedure.
And that's your Supreme Court this week. I am Tiffany Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navalio, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Jen Tuazon Iranya as researcher, Don Ryan Balza, Brian Austria, and Victor Laranio as sound editors, and Tyke Flores as web editor.